one of the firm's board certified specialists in condominium and plan development law, one of the very few of those in the entire state of Florida. From our Pompano office, please welcome Andrew Black. Andrew, take it away, my man.
Thanks so much, Jeff. Awesome job as always. Want to say hello. Really want to thank each and every one of you that took the time out of your hectic day, I'm sure, to spend some time with our firm. This is the Condominium Board Member Certification course. I am respectful of everyone's time, so we're scheduled for 2 hours. As Jeff said, I'll do my best to answer all of the questions I can. There are 7 topics that I will be going over today. The state of Florida actually only requires us to cover 5 for the board member certification course, but I will shoot for all 7. The first topic is the longest one, so I just ask you to bear with me a bit. But I've done enough of these, it feels like thousands by now, that it really works the best. I will take questions at the end of each of the 7 at the end of each of these 7 courses that I'll be going over today. Definitely type your questions in the Q&A, as Jeff said. Right off the bat, I kind of want to get in front of this. Is obviously, if you're on your condominium board, you may have heard of the new condo safety legislation. There was a Senate bill that came out dealing with various structural matters, various reserve funding matters, milestone inspections, structural reserve, that there's lots of new material regarding this condo bill. I'm not going to be going over that in depth today, and the reason is twofold. One, this is a general board member certification course, and there's lots of other stuff that needs to go over today. The second reason, perhaps more importantly, next Wednesday, the 17th, we will be having another free of charge, of course, course dealing specifically with the new condo legislation, the new Senate bill. So if you have not signed up yet, you can sign up. It's next Wednesday, again, the 17th. Also, our firm has previously given multiple courses on this new condo bill. They're all available to you free of charge on our site. Jeff is showing you on our firm site. You can click on it. You can watch it whenever you want. And we certainly encourage you to do so. But it's obviously way more in depth that we have time for today. So I just wanted to touch base on that. I don't want to waste anyone's time because invariably you may have specific questions regarding the new condo bill and how that may impact you all. It doesn't come into play as of now until 2024. So there are some possibility that there could be some changes in the next legislative session in 2023. So obviously keep your eyes out for that. Certainly, if you haven't signed up for our email list, we encourage you to sign up as well. We send out lots of free of charge, good legal updates for you. So having said all that, that's some administrative housekeeping things I just wanted to get out of the way. Again, thank you so much. I'm going to share the outline that we will be going over today. Again, it's the Condominium Board Member Certification course. The first topic is the longest one, again, so bear with me. But I like to define a couple terms before we jump in. I kind of like to set the mood for us about what we'll be going over. So what is a condominium? It's a not-for-profit corporation. It's organized under what's called Chapter 617 of the Florida statutes. That's the Not-for-Profit Corporation Act. And there's also a whole chapter of the Florida statutes you probably know. It's the Condominium Act. That's Chapter 718. So 718 is the primary chapter of the Florida statutes that I'll be going over today. But I think it's important to be mindful that there is the Not-for-Profit Corporation Act as well. That's in Chapter 617. So your primary role, if you're on your board currently, or you're thinking about running for your board, there's election season soon, your primary obligation is what's called your fiduciary duty to the owners. And this is really the prism that I want you to view what your role is as a member of your board. A fiduciary, it's just a fancy word. It means you're in a position of trust. It means that every decision you make as a member of your board, the primary goal should be what's in the best interest of the entire community. And if you, as a member of your board, take action that is geared towards what's in the best interest of the entire community, you would likely have met what your fiduciary duty is. And that fiduciary duty is expressed in Chapter 718, and in fact, it's in Chapter 617 as well. And the language of that statute, it talks about what would an ordinarily prudent person do if he or she were presented with the same facts. Would you, or have you, I should say, have you acted in the same way that an ordinarily prudent person would have done? And if you did, that's what's called using your reasonable business judgment, okay? Courts historically have provided fairly wide latitude to members of the board to use their business judgment to make decisions that's in the best interest of the entire community. And if there is a lawsuit brought by an owner claiming a breach of fiduciary duty, courts will analyze whether boards use that business judgment, right? And it's judged on a reasonableness standard. Of course, attorneys argue over what's reasonable or not. That's how law firms stay practicing, right? But at the end of the day, if you act reasonably, it is unlikely that a court will find that there was a breach of fiduciary duty. Now, acting reasonably means there's some due diligence required, right? You should have your contracts carefully reviewed. You should make sure you're interviewing the vendors you're considering, getting referrals from other communities they've worked on, doing all of those common sense things. But I think it's important to note that just because a decision of the board did not turn out the way the board intended it to, does not mean that the board breached its fiduciary duty. Let's say the board is thinking about hiring a new landscaper. You get competitive proposals. You have your attorney review it before it's signed. You do all of those common sense due diligence steps. The contract is signed 3 months into the landscape agreement. For whatever reason, maybe the landscaper is having personal problems in his or her own life, but the services start to fall and the landscaper is not doing a good job. Of course, owners, rightfully so, will bring that to the attention of the board. But at the end of the day, that doesn't mean that the board breached its fiduciary duty. It just means that sometimes things don't turn out the way they were intended to. So I think it's a good idea. I just wanted to take a minute to go over that fiduciary obligation that you as a member of your board have. And again, courts will analyze whether there's a breach of that fiduciary duty by looking at whether the board's used its business judgment, okay? I also want to just define a couple terms. If I say something is document specific, what does that mean? That means that every condominium, the original developer way back when, drafted the governing documents for your community. They are unique to you. I would not know what's in them unless I specifically reviewed them, okay? Chapter 718 of the Florida statutes does cover a lot of condominium areas, but it doesn't cover everything. And lots of times something's document specific, okay? It would be wonderful if every set of governing documents were the exact same, but obviously that's an impossible thing. Condos come in all shapes and sizes. So every set of governing documents is unique, all right? So if I say something's document specific, that's my friendly way of saying I wouldn't know, no attorney would know unless they review what those provisions say. Now, the governing documents themselves, you probably know this, but they consist of the Declaration of Condominium. That's the top one. If you're looking at it as a hierarchy, the Declaration of Condominium is the top one. That's essentially the constitution of how your community operates. It has the use restrictions, okay? That declaration, that's enforceable as any contract as an owner will ever sign. So obviously before you as an owner closed on your condo, you got a set of those condo docs, whether you read them or not, I'm not sure. But the primary takeaway from today is those use restrictions, those are binding as any contract that will ever be signed. So you've got the Declaration of Condominium. You then have the Articles of Incorporation, that's number 2. The bylaws is number 3. And any rules and regulations is number 4. So the Declaration, Articles of Incorporation, bylaws, and rules. Those 4 documents comprise what the governing documents are. Again, they're unique to every community. The Articles of Incorporation and the bylaws, those contain more of the corporate provisions, the notice for meetings, the size of the board, the eligibility of board members and officers. It's more on the corporate side, where the Declaration of Condominium, that contains the use restrictions. I think it's important to understand just how powerful that Declaration of Condominium really is. It's recorded in the county, so the public records have it, okay? And those use restrictions, the fancy word for them is they are covenants that run with the land. And let me break down what that means. A covenant is just a fancy word for what? It means a promise. So you as an owner are promising not to alter the exterior of your unit without board approval. You as an owner are promising to pay your assessments on time. You as an owner promise not to bring a commercial truck, right? Those are promises, and they run with the land. What does that mean? It means since it's recorded with the county, it binds your unit, it attaches to it, and it will be enforceable against every future owner that buys your condo. Okay, so they are covenants that run with the land. These are promises that every current and future owner of that particular condo unit is agreeing to. So I certainly, if you're thinking about buying another condo unit and another condominium, you obviously want to make sure you know what you're promising to, all right? I think it's just important. I just wanted to go over some of those defined terms, okay? Now, another primary obligation of the association, again, this is part of the operations, is obviously to manage, operate, and maintain the common elements property. And I'll try to make it as simple as I can. But there's only two types of property in the condominium. There's the individual units themselves, and then there's all the property outside the boundaries of those individual units, which are considered common element property. Now, there might be certain common element property that is reserved for the exclusive use of that owner, perhaps a parking space or a storage closet. Those are often deemed limited common element property, but they're still common element property. And the obligation of the association to maintain, operate, and maintain the common element property, that's referenced in the statute. But it's also very important for you all to know that the specific maintenance obligations of the common element property, that's document specific. Okay, so there might be a certain plumbing pipe. Maybe it's behind the drywall. Maybe it services more than one unit. Maybe it only services one. But the question is the association responsible for that specific plumbing pipe? That's document specific. Okay, I can say typically if it's a common element pipe and it services more than one condo unit, typically it's the association's obligation. But if, let's say it's behind the common, if it's behind the drywall, right? It's behind the paint and it's in the common elements, but it only services one unit. I've seen governing documents be drafted both ways. I've seen it where the owner is responsible and I've seen it where the association is. So if you have a particular question on who fixes what, absolutely, it's a document specific thing, and you should make sure you get with your association's counsel on that. Regarding the operation of the common element property, a common question we get a lot, and certainly want to take a minute here today, is the concept of what's called a material alteration to the common elements. You probably have heard that phrase, material alteration. And there's case law in Florida that has held that a material alteration essentially means some perceptible change in the look or use of the common element property. And the state of Florida, via the DBPR, has a whole agency, the Division of Florida Condominiums. That's the state agency that regulates condos. There's several published arbitration decisions where the state takes a fairly conservative approach on what constitutes a material alteration. And they have held even a change of color of the paint. If you're going from white to red, that's a material alteration. So the question naturally arises is, does the board on its own, without a vote of the owners, does the board have the authority to undertake a material alteration? And it's really a two-step analysis. The first step, and this is right in the Florida statutes, right in 718.113, and it's right in your outline as well. The statute says that unless your governing documents, unless your declaration of condominium says something else, then a material alteration must be approved by 75% of all owners. Now, that unless your declaration says something else is a very important phrase. What does that mean? It means the first step is you need to have your documents reviewed. I've seen lots of material alteration provisions where it allows a material alteration to be undertaken if it's approved by 2/3 of the owners or a majority, 50% plus one of the owners. I've even seen it where the board has the authority without a vote of the owners to undertake a material alteration, as long as the cost of that alteration does not exceed a certain dollar amount, whether it's 10 grand, 50 grand, whatever. But if it's less than that cost, the board has the authority without the vote of the owners. And I've seen where if it's over that dollar amount, then you either need a majority of the owners, 2/3 of the owners, 75%. So the point is that your declaration could have a wide variety of material alteration provisions. Again, if it's silent, the statute says you need 75%. But the first step is certainly see what your governing documents say. So if you're on your board now and you're thinking about a material alteration, you're thinking about a capital improvement project, right? Then make sure you consult with your attorney, make sure you get written guidance on whether you have the authority to go forward or not. Because if you do go forward and you did need owner approval first, and an owner files a legal challenge with the state of Florida, you could be looking at certainly an adverse result where you could perhaps be forced to restore whatever change was done without proper owner approval. Okay. Now, it's important to highlight in this material alteration analysis, which is there's a big exception where you do not need owner approval. That big exception is the necessary maintenance exception. And as I explain it, hopefully it makes sense. There's case law in Florida that is held that if the project that the board is going forward with or wants to go forward with, if the primary purpose is the necessary maintenance of the common element property, the board not only has the authority to go forward without any owner approval, but it must go forward. Okay. And there's a famous case in Florida. There was a seawall that was in bad shape. The board wanted to ensure that it was fixed. It consulted with its licensed professionals, engineers, and contractors who stated to the board that the best way to protect the condominium building was to install a new style and type of seawall. That new style and type of seawall was a material alteration, right? It is a perceptible change of how the common element property looked. However, since that change was required, it was necessary to maintain, the court held that the board had the authority to go forward without owner approval. And if you think about it, it makes sense, because what if the board presented that seawall alteration out to the owners to approve? The owners voted no. Then was the board supposed to just let the seawall crumble and expose the condominium to possible future harm? Hopefully you agree with me. That would be an absurd result. The answer is no. So I think it's important to keep in the back of your mind the necessary maintenance exception to the material alteration analysis, which again, if your documents are silent, you need 75% approval for the alteration. If your documents are not silent, you follow what's in there, except for that required maintenance exception. All right. So just want to do a couple more topics on the operations, then I'll take questions. And again, the rest of the topics are much shorter. I think it's important to highlight that part of the operational aspect of the association is you have the right of access to each individual unit. Okay. When you buy a condo, you do give up some of your individual property rights. It's not like you own a single family home. You're buying your own property, but you're doing it with what? There's shared walls, there's common element property. And in the statute, it's right in chapter 718, it says the association has the irrevocable right to access each unit when such access is required for the association to ensure that the common elements are being properly maintained. Obviously, if there's a bona fide emergency, hopefully you all know they can use those access rights, but it doesn't need to be an ongoing emergency. Obviously, if there's a burst pipe and water's going everywhere, or there's a fire, obviously they can use those access rights. But they have access rights. Let's say the association is doing a concrete restoration project. The exterior of the building is being structurally repaired, and the best way to access that common element exterior property is through the units, the balconies, let's say. That's a common fact pattern. The association does have the right to access those units when it's required to ensure that the common element property is being repaired. So I just like to point out that right of access there. And also, I should have probably said this before I started, but my style is obviously, I'm not going to be reading line by line from the outline that you all have. I tend to think if you all have plenty of opportunity, you have this outline, you can read it line by line. I encourage you to do so. But my primary objective today is to go over the most common topics that our firm sees dealing with our condominium association clients. So that's what I'm choosing to focus on. I want to talk about part of the operation aspect is the insurance aspect. Okay. Obviously, hopefully, I shouldn't say obviously, hopefully you all know it's right in chapter 718 that the association is required to insure parts of the condominium property. Okay. The way the statute reads is they're required to have property insurance for everything. But then the statute goes on to say, and let's see if I can use my little pen here. There we go. My wife, who's an artist, would hate that horrible star I just drew. But what I'm starring is what the statute says is expressly excluded from the association's insurance requirement. What does that mean? That means these items are the insurance obligation of the individual owners. And it's common sense stuff, right? It's the personal property within the unit. It's the coverings of the floors, the walls, the ceilings. If you have carpet, tile, it's appliances and water heaters and window treatments and curtains. Those interior things are the insurance obligation of the owner, okay? And that's important because this insurance analysis comes into play if there is what's called an insurable casualty event. What does that mean? It means a sudden, unforeseen event, such as a hurricane, okay? Let's knock on wood somewhere that will be free from hurricanes. But if there is that casualty event and there's property damage following that casualty event, the analysis is whoever insures the damaged property is the party responsible to fix that damaged property. So if the roof of the condo is damaged following a hurricane, the roof is the insurance obligation of who? Of the association, right? So the association is the party responsible to fix that damaged roof following a casualty event. Of course, if there's an item that the owner is responsible to insure, the kitchen cabinets are damaged from a burst water heater. Those kitchen cabinets, since the owner insures it, the owner is responsible to fix what was damaged from an insurable casualty event, okay? The law loves exceptions, so I would be remiss if I didn't point out there is an exception that would allow the association to hold the owner responsible to repair an item that was damaged, even if the associations were responsible to insure it. And that exception is when the owner did something wrong. They acted in a improper way. And I use this not common, but I use this fact pattern that our firm had to deal with, which is an owner thought it was a good idea to use the fire sprinkler in their unit to hang their clothes hangers. Hopefully we all can agree that's unreasonable. That's improper. The weight of the hangers caused the sprinkler to have a sudden, it burst. There was significant water damage that impacted not only other units, but impacted the common element property between the condos, okay? In that case, even though the association is responsible to ensure the common element property, since the source of the casualty event was the improper conduct of the owner, the association was able to seek recourse directly from the owner that was at fault. Hopefully that makes sense to you all, but I just wanted to point that out. Okay, a couple other items on the first topic. I want to just go towards the bottom of this page 5, which is enforcing the covenants, right? Again, covenants is just a fancy word. It's the promises that you as an owner make. And this is really dealing with the board enforcing what your restrictions are, right? Sometimes boards get a bad rap where owners say, "You're condo commandos. Why are you bothering me? Leave me alone." And I certainly understand that. I mean, the board always needs to act in a reasonable way. But, and this is an important but, part of the board's fiduciary duty to the community is to ensure that those use restrictions, those rules and regulations are uniformly and timely enforced against all owners and occupants. And let's break that down. Uniformly means what? It means against everyone. So there should not be arbitrary enforcement. Boards shouldn't pick and choose. We're only going to enforce the commercial truck restriction against the owners we don't like, but our friends, we're going to allow them to have commercial trucks, right? That will only lead to owners possibly pursuing a selective enforcement defense against an association enforcement action, okay? So the board's enforcement should be uniform. Board's enforcement should be timely as well, right? Uniform and timely enforcement. It's our suggestion to avoid claims of lack of timely enforcement, that the board should be enforcing these rule infractions within 1 year of when the board knew or should have known that the violation exists. Now, knowing that a violation exists, that's pretty obvious, right? The board's aware of it, but also it should be within 1 year when the board should have known the violation exists. What does that mean? That means that it's not required that every member of your board have actual knowledge that an infraction is there. But if the board should have known, so if you have a commercial truck restriction and the truck's parked there and it's been in the community for a prolonged period of time, certainly for over a year, I think the owner has a possible what's called a waiver defense. And that owner, in theory, could assert, they could state, association, you've sat on your hands for so long. My truck has been there for so long. You should have known it was there. I don't care that every board member didn't know, but it's been parked there. It's readily obvious. You should have known it was there for so long. You sat on your hands for so long. Therefore, you have lost or waived your ability to now seek enforcement against me. Okay, so boards, you want to be certainly cognizant and aware that you're uniformly and timely enforcing what your restrictions state. Now, if you're out there thinking, oh my goodness, our board has let lots of violations slide for a long period of time, what do? We want to be able to uniformly and timely enforce that commercial truck rule against everyone without worrying about the potential for an owner to raise a selective enforcement or a waiver defense. And I have some positive news for you. The law does allow, there is a way for the board to once again restore the viability of a restriction that may have been lost due to lack of uniform or timely enforcement. That process is called the republication process. It sounds complicated, it's not. The republication process is done by a board vote. There's no owner vote required. And it essentially just means that the board, at a duly noticed meeting of the board, votes to approve republishing Article XYZ of your governing documents that prohibits, let's use that commercial truck example. So the board approves to republish that commercial truck restriction. You then, after the board meeting where that republication was approved, you must send written notice to every owner that informs them at a board meeting held on whatever date this Article XYZ was approved. It's now going to be enforced from this date forward. Okay. Now, the caveat to that republication process is all existing, let's use that commercial truck fact pattern, all existing commercial trucks that are in the community on the date that the republication notice is sent, they're allowed to remain. They would be what's called grandfathered in. I'm sure you've heard that phrase. Okay. So let's say there's 10 commercial trucks that have been in the community for a long period of time. The board doesn't want to allow any more commercial trucks because your documents restrict them. You would do the republication vote at a meeting of the board. You would send the republication notice out to all owners. Those 10 existing commercial trucks, they're grandfathered in. However, commercial truck number 11, 12, and so on, the board could enforce and require them to be removed. And if the owner of commercial truck number 11 says, hey, what about commercial trucks 1 through 10? The board can state, yes, those have been grandfathered in. We republished, we restored this commercial truck restriction. A memo was sent out to all owners. Since you got your truck after that date, we can enforce it against you. Okay. Now, certainly in the republication notice that's sent to all owners, you can and should require those owners of commercial trucks 1 through 10 to register those trucks with the board. So you have a copy and you know which trucks are grandfathered in. Also, it's important to note that it's just that specific commercial truck that's grandfathered in. That owner isn't grandfathered in permanently. So that owner can't get as many commercial trucks as he or she wants. It's just that specific truck. So I thought it was important to just touch base on the obligation of the board to uniformly and timely enforce your restrictions. Obviously, the enforcement process, you need to send the written notice out to the owner, give them an opportunity to cure what's wrong. If they don't comply, obviously, you might need to then get your attorney involved to send a more formal demand. There's also the authority to fine an owner. The fining process is set forth in the Florida statutes. It's in your outline as well. It does require an independent committee to be established of other owners who are impartial. They can't be on the board. They can't be related to anyone on the board. And the way the fining process works is you need to send a 14-day notice to the owner, letting the owner know that the board has approved the fine and that the owner has the opportunity to be heard before this impartial committee. At that committee hearing, you want to think of it like a mini due process trial where the association is like the prosecuting attorney, the owner is the defendant, and that impartial committee is the judge/jury. And that impartial committee has the final authority to either confirm or reject a fine. All right, a fine, it's right in your outline, cannot exceed $100 per infraction, up to $1,000 in the aggregate for a continuing infraction. So if you have that commercial truck, it's parked there for 10 days, you could fine them $100 a day, up to $1,000. So it's just, it's certainly good to know that fining out there. Fining, of course, doesn't cure the underlying infraction. An owner could just pay the fine and the truck is still there. So if you want to, compel the owner to get rid of that truck, that's when you need to get with your attorney to explore whether filing formal legal action is appropriate. Obviously, the collection of assessments is an important operational aspect. the assessments, whether you pay them monthly or quarterly, that's the lifeblood of how your association operates, right? And if owners don't pay assessments on time, the way condominium world works is it's the other owners that have to make up for that, right? And if you have an issue in your community where you have delinquent owners, you may want to review what your assessment collection policy is. I think it's important for owners to be aware of that. There was a change in the Florida statutes that before an owner can be referred to your attorney to pursue formal collections, there is a statutory 30-day letter that must be sent. Lots of boards send courtesy delinquent notices as well, like a first 10-day or a 20-day. But certainly if you're not aware of this new statutory 30-day notice that must be sent, definitely get with your association's counsel. Certainly if you have a licensed property management company, they should be aware of this new 30-day notice that must be sent before a collection file gets referred to our firm. All right. Obviously, there's special assessments as well, right? You pay your regular assessments monthly or quarterly, but sometimes there's unanticipated expenses. No one wants to hear the dreaded phrase special assessment. But if there's a necessary maintenance project, oftentimes, and there aren't available funds, oftentimes a board's left with no choice but to adopt a special assessment. And the way the statute works is that the meeting of the board has to be noticed 14 days prior. That 14-day notice is mailed as well as posted 14 days in advance. And that special assessment notice must state that a special assessment will be considered. It must state what the approximate cost is and certainly what the reason is. All right. So if you're a board and you're thinking about adopting a special assessment, I think it's prudent to get with your association's counsel, make sure that the notice, that 14-day notice of the board meeting is done right, because you don't want to do it improperly, because then if an owner does not pay, you won't be able to formally collect it. All right. Last topic on the operations, and then we'll take some questions and then we will go on. Meetings of the association. I just want to generally talk about what the meeting process is. I think lots of times people get confused. I think it's helpful. The first question to ask is, who's voting? If it's just the board, it's a meeting of the who? The board, okay? If owners are voting, who is it a meeting of? It's a meeting of the owners, right? So a meeting is either a meeting of the board or a meeting of the owners. The meetings of the owners, okay? The most common one is the annual meeting. That's where the election happens. And I'm going to go in depth on the election process soon, so I won't go into that now. But there might be other special meetings of the owners where the owners vote. Let's say you're required to get an owner approval for a material alteration, right? That vote is done at a special meeting of the owners. And the notice of that special meeting of the owners is document specific. You want to follow what your documents say. If your documents are silent, the statute states you need 14-day notice mailed to all owners, okay? Now, you can send notice via electronic means to owners via email if you have the signed consent from an owner for the association to use that owner's email to send them official association things. So if you want to just use email only, you need to have the signed consent of that owner. If you're mailing the notice to the owners of that owner's meeting, you can certainly email in addition to, but you can only exclusively use email notice if you have that owner's signed consent. Certainly for meetings of the owners, for the meeting to even happen, you need to establish what's called quorum. I'm sure you've heard of that. Quorum is just a fancy word. It means the minimum number of owners that must be present, either physically present or there via proxy. Okay, without quorum, the meeting cannot be held. Quorum is document specific, but it's typically a majority of all of the owners. A majority is 50% plus one. So that's membership meetings, right? The other types of meetings are meetings where the board votes. That's meetings of the board, okay? Regular meetings of the board, you only need notice posted 48 hours. That notice should have an agenda, obviously, right? And there should be minutes. There's minutes of owners meetings as well, but there should be minutes taken of the board meetings. The minutes are not a transcription of every word that was spoken out loud, right? The minutes of the board meetings should simply be the time the meeting was called to order, who was there, the motions that were made, how those motions were voted on, and really when the meeting was adjourned. I've seen some minutes of board meetings that are pages and pages long. That's really not required. And we suggest keeping minutes to just those items, okay? Again, notice of regular board meetings just needs to be posted 48 hours. There's a couple exceptions where the notice of the board meeting must be mailed and posted 14 days, excuse me. There's exceptions where notice of board meetings must be mailed and posted 14 days prior. That's meetings I already talked about. One where special assessments will be adopted. That's a 14-day notice. If the board is considering adopting rules regarding the use of the individual units themselves, that's a 14-day notice as well. All right. All right, let's take some questions. Again, this whole course today is really for general board member education reasons. Invariably, we get questions from members of the board that are very fact specific. And sometimes they'll cite a copy of a letter that was sent out, or they'll cite a section of your governing documents and they'll ask me a specific question. Obviously, those need to be directed to your association attorney. I'll give my little attorney spiel now, which is everything I'm saying here today, again, is for general information, right? So what I say should not be construed as specific legal advice for your particular fact pattern, right? So it wouldn't be accurate or proper if you're on your board to go back to your other members of the board and say, I met with an attorney, he gave me the advice that we're authorized to do this. You know, that wouldn't be proper. So if I don't address your question, it could be because it's very, very fact specific. So I, don't want you to be offended on that. We got a very good question regarding does the board have less obligations if they have a third-party property management company? And certainly that could be a great idea, a great help to you all to hire a licensed property management company. They will handle a lot of the day-to-day matters. But at the end of the day, it's important to note, a property manager is just the agent of the association. So they take direction from the board. So at the end of the day, it's a majority of the board that approves signing a contract. So the board wouldn't be able to, quote unquote, blame the management company unless there's evidence that the management company engaged in improper conduct. So at the end of the day, a management company is just the agent of the condo. We got a question regarding whether certain areas are part of the common element property or not. Again, that's condo document specific. So you would have to check your documents on that. We got a specific question about what's a material alteration. Again, the state of Florida takes a very conservative approach. They think a change of paint, colors, and alteration I certainly can't go over the laundry list of every possible item that could be a material alteration. My suggestion is to you, if you have a question about a project, get with your association attorney before you go forward. We got a question about, can we convert a portion of the common elements to limited common elements and make them available just for the exclusive use of the owners? That's a document specific thing. What I will say is there's language in the statute, and this isn't dealing with converting to limited common elements. Let's say you have a common element clubhouse. There is language in the statute that allows the board to rent that out to an owner for a certain period of time, and the board can even charge them a fee to have the exclusive use to that, for instance, that clubhouse.
Andy, I'm just going to mention really quick, a couple of folks typed questions into the chat area. Please type them in using the Q&A function. The chat area is just to communicate with me, a non-attorney, on any techie items related to this. Maybe you're having some technical issues or administrative questions that I can answer. But keep any pertinent questions to the topics in the Q&A, not the chat area. And to those of you asking if you can have the course materials, yes, we'll go over it again later. The link to download the same materials you see on the screen will be on the evaluation page, and we'll go over that again a little bit later. Back to you.
Great, thank you. I got a handful of questions regarding insurance. Who's responsible to insure what? Again, that's in the statute. It's in your outline as well. If there's a hurricane and the kitchen cabinets are damaged, it's the owner's obligation to repair the kitchen cabinets. Obviously, there could be lots of damage. There could be a hurricane, a ceiling comes crashing down, and the carpets are damaged. Obviously, the carpets are the owner's insurance obligations. The windows themselves, if there's a casualty event, the windows themselves under the statute would be the association's insurance. If an owner does not have insurance and there's a casualty event, the owner is still responsible to repair those items at his or her cost. Unless your governing documents specifically authorize the board to mandate that an owner provides proof of their individual insurance, the board doesn't have the authority to just adopt the rule to require that proof of the insurance be turned in. But certain communities have amended their governing documents to make that an obligation. We have lots of specific questions on who maintains what. Again, the general day-to-day maintenance, we're not talking about a casualty event, just the general wear and tear day-to-day. Those maintenance obligations are document specific. Okay, so you need to get your governing documents reviewed. Okay, we got a question on topics that I haven't gone over yet regarding the recall and election. I will get to that, so just be patient with me. Okay, lots of questions from the same individual, which I appreciate it. These are all fact specific regarding the notice requirement. Can we only post the notices? How much notices do we need to give? All the notice requirements are in your outline. If it's a board meeting, it's regular 48 hours. There's a couple exceptions that require 14 days, as I spoke about. And for owners meetings, unless your document states something else, it's a 14-day notice. All right, I'll take a couple more questions, and we will then move on to the next topic. I got a question about, should the board adopt like a code of conduct, the way board members should operate? Certainly a good idea. You can't force a board member to sign it. The board members already have a fiduciary duty. So, whether they sign it or not doesn't really change that, but certainly it could be a good idea. I got multiple questions about the sale and lease application process and what factors can be used to reject someone. That's a little bit outside the scope of what we're going over today. I will share with you, and Jeff, there it is, that we are giving an entire course on the sale lease approval process, August the 25th. So I encourage you to sign up for that course. It's at 12 noon as well. It'll be hosted by yours truly again. So again, August 25th, for any question regarding the sale or lease approval or application process.
I'll put the direct link to register for that into the chat area right now.
Great. Thank you. Okay. All right. I'm going to go on to the next topic to make sure I can cover everything and get to lots of questions. Any insurance questions about, whether we could, what our rates will be, or is there even a way to self-insure, all those types of things? Definitely, you're going to want to get with your insurance agent on that to make sure you have sufficient insurance coverage. Okay. I will address one last topic because I'm getting a couple questions on this regarding what is do we have to notice a meeting every time there's a quorum of the board just, in the same physical space? And my opinion is no. There's some legal practitioners out there that perhaps take a more conservative view. But the statute specifically allows board members to communicate via email. They just can't formally vote via email. And in my mind, if you can communicate via email, it makes sense that you can communicate over the phone, just can't vote over the phone. And if you can communicate over the phone, to me, it makes sense that you can communicate face to face. You just can't vote on items face to face. Any vote or any substantive decisions that the board is making, that should only be done at duly noticed meetings of the board, where owners obviously have the opportunity to attend and speak on the designated agenda item. Okay. Again, very specific questions on what certain contractual agreements say. Let me move on to the next topic. The annual budget and reserves. Obviously, hopefully you all know you have an annual budget that's adopted each year. The notice of the board meeting where the budget will be adopted, that's one of those exceptions where the board meeting notice must be mailed and posted 14 days prior, and a copy of the proposed annual budget is included. There's two sides. One side is the operating expenses, and those operating expenses are right in your outline. It's common sense things, right? What are the anticipated costs for your property management, for your insurance, for your accountant, for your attorney, for your landscaping, right? Those expenses are a good faith estimate based on what the prior year's expenses were, right? So you obviously look at what your expenses were, and that's how the board comes up with that number for the following year. So that's the operating expenses. There's also reserves. Right now, as the law stands now, and again, I'm not talking about the new Senate Bill 4D, but the way the law stands now is your annual budget that must be adopted must have what's called fully funded reserves for 4 items. And this is the way the law is right now. Those 4 items are right in your outline, and I'll do a little note. There's my horrible star. But roof replacement to building, painting, pavement resurfacing. And the 4th item is the catch-all item, which is any other deferred maintenance or replacement that exceeds $10,000. And the board is required to have fully funded reserve accounts for those 4 items unless, and this is a big unless the board has presented the option to the owners to either partially fund reserves, which is just less than full, or to completely waive funding of those reserves. That vote is good for that year. Okay, so you do need owner approval right now. The option still exists to either partially fund reserves or to waive reserves for that year. If the board decides not to present the partial funding or the waiver issue to the owners, or they present it to the owners, but they don't get the required majority of quorum approval from the owners, then your annual budget is supposed to have fully funded reserves. And what does fully funded mean? It means you need to know what the remaining useful life of that reserve item is. The roof, let's say there's 10 years left. You have 10 useful years left. And you have qualified professionals come out. They say, look, you have 10 years left. It's going to cost you $100,000 at the end of that 10 years to fix the roof or to replace it. Okay. To have fully funded reserves, and attorneys hate math, that means you need to fund 10 grand each year for those 10 years. You then have that $100,000 in your roof reserve, and you have quote unquote those rainy day funds to replace that roof. Okay. The purpose or the goal, the underlying goal to have fully funded reserves is to avoid a large special assessment that may be required if you do not have adequate reserve funds. Oh, I'm sorry. Let me get out of this. All right. Now, if you have reserve accounts established and you have what's called straight line reserves, you have a separate roof reserve, you can only use those funds in that roof reserve for the roof. You can not use it for an alternate purpose unless, and this is the bottom of your outline, right, in subsection 4, you cannot use reserves for an alternate use unless that alternate use is approved by the owners, okay? So if you have a statutory reserve account, you can only use the items, you can only use, the funds in that reserve account for that specific reserve item. Now, the law does allow the association to establish what's called pooled reserves, and it's right in your outline. That's when you group the individual roof, roadway reserve accounts into one pooled account, and then you can use the funds for either of those items in the pooled account. Okay. But I think it's important to note, if you're thinking about using reserve funds for something else, make sure you get with your association attorney to make sure you're not running afoul of the Florida statutes. We already went over this part, but the board meeting to adopt the annual budget, that notice must be mailed and posted with a copy of the proposed annual budget 14 days prior. I also touched base on that the annual budget must have fully funded reserves. As the law currently stands, you can only waive or partially fund reserves if you get an owner vote. Okay. All right. With that being said, I'll take some questions on just the topics I went over. I had a question on emotional support animals, sort of outside the scope of what I'm going over today. I certainly encourage you, if you have any emotional support animal or any fair housing, disability questions, we give lots of free courses on it. You could go to our site. I'm sure there's courses available, but just a quick answer is, if a person establishes that they have a disability related need for that emotional support animal and a health professional confirms that, the board likely will need to approve and allow that emotional support animal. I got a question where the governing documents require, this is going back to the material alteration, they require 75% owner vote. Someone asked, is there a way to get around that? And I wish I could work magic, but no. If it requires 75%, you need to get 75%. And if you don't, you're subjecting your association to possibly an owner filing successful legal action against you. I had a question about reserves. I just went over this, which is if you have funds in a reserve account, you can only use it for an alternate use if you have that alternate use approved by the owners. I had a question about where it looks like there's a master association where there's several condo associations under 718, and maybe there's homeowner associations governed under 720, how that all interplays with one another. That's a very document specific thing. You're going to need to get with your association's attorney on that. Okay. We got a question about charging non-refundable fees. Let's say a $500 flat fee for the condo maintenance staff to take away balcony furniture when there's a hurricane coming. I prefer, for enforcement reasons, that your governing documents are actually amended to authorize those non-refundable fees. I think if the board imposes those non-refundable fees just by a board vote, I do think that leaves some room for an owner to file a challenge that non-refundable fee is outside of the board's rulemaking authority. So you just want to be cognizant of that. Got another question about material alterations, the style of a roof, going from a shingles roof to another style. Is that a material alteration? Again, I can't list every single fact pattern, but certainly, in my opinion, if a challenge was raised by the state of Florida or was raised to the state of Florida, it's likely that they would rule that a change of roof style, and there's even arbitration decisions on this, would likely be considered a material alteration. So you want to proceed with caution on that. Let me take a couple other questions. Again, if you want to use email notice exclusively for notices of meetings, you should have the consent of the owners that they authorize you to use their email for official association things. It's not enough that you just have their email in their application form. In my mind, you should have their signed consent. I, John Doe, authorize the association to use the following email address as the exclusive means to send me notices of the annual meeting or special owners meeting. I think it's best to have that signed consent on file. That way there's no gray area. Okay, we got a question about the temperature of the swimming pool, and that's a controversial thing. Again, ultimately, that's the board's call on what the pool temperature should be. There is language in the Florida admin code. There's very minute requirements on what pool signs need to be put up. So you want to make sure that you're complying with all codes. But certainly, hopefully there's not too big of an argument about what the pool temperature is. Regarding the assessment, once an owner becomes the record owner, from that date going forward, they're responsible for all assessments. And just because they became an owner on August the 1st and a special assessment was adopted August the 3rd, unfortunately, it's one of those too bad, so sad. And I don't say that in a lighthearted way. I just say that any owner of a condominium has to take title knowing that it's possible that a special assessment could be adopted after they become the owner. We got a question about board member communication and who has the authority to speak to the attorney or to the property manager. At the end of the day, it's a majority of the board's decision. You have a 5-member board, a majority is 3, right? You have a 7-member board, majority is 4. You have a 3-member board, majority is 2. You have a 9-member board, majority is 5. Ultimately, it's a majority of the board who approves who is the authorized contact, to either your association's attorney, to your property manager. I mean, it's best to streamline these things. You don't want 7 board members contacting your attorney on the same thing. You're not going to love possibly the charge that you might get, right, for 7 board members asking the same thing, but also you want to streamline communication. It is very important for any organization at all that the communication is streamlined. All right, take a couple more questions and then we'll hop on to some other topics. I appreciate people. You don't need to write thank you in the Q&A. I will assume that you're saying friendly things if I address your question. Got a good question on right now, the way the law stands, the board is not required to allow the owners to vote to waive the fully funded reserves. That's a board decision. We have some clients that have either fully funded or who have either waived reserves or partially funded reserves for a long time. So owners might not be happy if the board all of a sudden did not allow them the opportunity to, but it's not required. It's the board's choice whether to present a the question whether to partially fund or waive reserves. Okay. We got a question on committees. Committees serve at the pleasure of the board. Okay. The only language in the statute regarding notice of a committee meeting is the fining committee, whether you call it the fining committee or the grievance committee. Those meetings, obviously, to find someone, you need to send out a 14-day notice. The role and scope of all other committees besides the fining one, that's a document-specific thing. And if the documents are silent, it's the board that has the authority to establish what the role and function of that committee will be. Typically, it's best if that committee is more of an advisory role to the board without giving that committee final binding authority. If you do give that committee final binding authority to take action on the board, then those committee, you need to clearly allocate that, make sure that their role is established. Okay. We got a question. Can board members communicate via email and just exchange information? The answer is yes. You can certainly exchange information with board members via email. The last question I got on these first topics before I go on is, can we charge a capital contribution at the point of sale? The state of Florida says no. If you're in a condominium, even if your documents are amended, which I personally don't agree with, but if a challenge is raised with the state of Florida, it's likely that if you try to charge a capital contribution in a condominium association at the point of sale, they'll say that's improper. And they'll say that because the statute says the maximum amount that can be charged at the point of sale is just a transfer fee, right? It used to be $100, it was just increased to $150. So the answer is no. Possible committees, you could have, beautification committees, you could have social committees, you could have rule committees, you could have any architectural committees. There are really anything the board can think of. The board can appoint those members. Again, they serve at the pleasure of the board. And it's my suggestion, it's probably best that they're more of an advisory role. All right, with that saying, let's keep on trucking along here. You guys are asking great questions. I appreciate it. The next topic is, I think, the fastest one. This is the financial reporting. Hopefully you all know that you need to have an annual financial report prepared each year. It's annual, and owners get a copy of that financial report for free, or they get notice that a copy is available to them for free. The level of financial reporting is based on what your revenues are. And the list is right in your outline, okay? It goes from the lowest level to the highest. The lowest level is just a simple report of cash receipts and expenditures. The next is compiled financial statements. After that is reviewed. And then the most comprehensive is an audit, right? So if you have an annual revenue of at least 500,000 or more, you need an audit. So obviously be aware of that, know what your annual revenues are, and make sure you're you know, having those financial statements prepared to make sure you're informing owners that a copy is available to them free of charge. Now, we get asked from time to time, let's say your annual revenues are $400,000. Per statute, you need to do reviewed financial statements. The question you get asked is, can the board increase the level? Can they do an audit? The answer is yes, absolutely. The board has the authority without an owner vote to increase that level of financial reporting. What the board cannot do, however, is decrease the level of financial reporting without advance owner approval. So if you have $400,000 of annual revenues, you're required to prepare a reviewed financial. You would not be able to lower it to compile the financial statements, for example, without an owner vote. All right, a couple other important governmental financial filings that you should be aware of. I talked before about the Florida agency that regulates condos. It's the Division of Condominiums. You are required to pay an annual fee of $4 per condo. That's how they, that's like the economic stimulus. That's how the state funds their various condominium programs, as well as their arbitration section. Also, I mentioned at the very top, every condominium is a not-for-profit corporation. You have your articles of incorporation are actually filed with the state of Florida Division of Corporations. You might have been to their website. It's www.sunbiz.org. So it's sunbiz with a z.org. There you can type in your corporate name of your condominium, and you can see hopefully that you filed your annual report with the state of Florida each year. It's due between January 1 and May 1st. If you're late, you'll have an inactive corporate status, but you can regain active status. You'll just have to pay a late filing fee. So just be aware of that. Obviously, check with the Division of Florida Corporations. The last filing I just want to touch base on is, obviously you're a not-for-profit corporation, but that does not mean you won't ever have any income at all. While assessments aren't considered income for tax filing reasons, you could have a common element laundry room where you're getting income from owners. You might have a bulk cable agreement where the cable provider cut you a nice check, like a per door fee. You could have fees related to where you rented out the clubhouse to owners and you collected fees. So the point being is get with your financial professional as far as your annual income tax filing. All right, so that's the record inspection. We got a question about HOAs governed under 720. This is the condominium board member certification course. We do give lots of HOA board member certification courses as well. The question regarding HOAs were regarding capital contributions. The law is a little bit different in HOAs. And if an HOA governing documents allow a capital contribution, there is support to hold that would be a valid charge. But again, I don't want to confuse people, and I encourage everyone to attend any future HOA courses that we have. All right. Next topic is, I think, an important one, and it's a commonly misunderstood one, but this is the official record keeping process. Hopefully you all know you all are required as an association, it's right in the statute, to maintain the official records of the condominium. I'm not going to read the list there, it's common sense things, but I do want to point out the last one here, which is right here. This one here, it says all other written records of the association that are not specifically identified in the statute, which are related to the operation of the association. That is a catch-all provision. That means the legislators got tired of thinking of every possible item that might be part of the records that the association has to keep. Therefore, if it's a written record and it relates to the operation of the association, it's likely, more likely than not, it would be deemed part of the official records that must be kept. Okay. Owners under the statute have the authority to have access, and they can copy the official records of the association. If you get a written request from an owner to have access to the records, you want to make sure you're providing an available date, time, and location within 10 working days. Okay. So be aware of that 10 working day time frame. You don't want to ignore a request to inspect the official records. If you do, it could subject the association to monetary damages, and you just want to avoid that. Now, while an owner has the ability to inspect and have access to the records, that does not mean they get to send you a letter that says, I demand that you find me these 7 things and you email them to me. Okay. The association is not required under the law to call through its records, find exactly the 20 things that an owner wants, and then hand it over to them. Your only obligation under the law is to make the records available in the manner in which they're kept in the ordinary course of your operations. Okay. So you can certainly, and we see this from time to time, unfortunately, you might have an owner that is using the record inspection process to perhaps be a thorn in the association side, but you can absolutely schedule an appointment and just have the boxes available for an owner to inspect him or herself. Obviously, if it's easier for management or easier for the board to find exactly what the owner wants and hand it over to them, you certainly can do that. I'm just mentioning that you're not required to go that far. You're only required to make them available for inspection. The rule of thumb is you must keep everything for 7 years. There's exceptions, of course, but that's the rule of thumb. Okay. Minutes of meetings and your governing documents must be kept permanently. So you never should throw those out. Minutes of meetings and your governing documents kept permanently. Everything else, 7 years. I'll make one other exception. Any voting materials, ballots, voting envelopes, proxies, sign-in sheets when a vote was taken, all those voting materials only need to be kept for 1 year. Okay. So the rule of thumb is 7 years, voting materials only 1 year, and minutes of meetings and governing documents you never get rid of. Those must be kept permanently. Okay. Now, there are certain items that you should be keeping as part of the official records, but they are private. They're confidential. Owners don't get access to them, and they're at the bottom of your page 19 going on to page 20. Those are such items as attorney-client privileged material. You get an opinion letter from your attorney on a pending matter. That's privilege. Owners don't get to see it. Okay. If you have the authority in your documents to review and approve someone who wants to buy or someone who wants to rent, the information you obtain in connection with that approval process, that's private. And what they're really talking about is that background investigation report. That's private. Other items, personnel records and files of association or management company employees, those are kept private. Any hospital or medical records of owners, that's private. Any personal identifying information of owners, such as social security numbers, driver's license, credit cards, those things are kept private, with the exception of emails are open for inspection if an owner has either consented to making them open for inspection or an owner has consented to receiving exclusive notice of meetings via email. If they've done that, emails are open for owners' inspection. Okay. So you want to be aware of what records are kept private, and you obviously want to ensure that if you have a file for each owner, it's probably a good idea to have a separate tab for what's private, like the background report, or any other, driver's license, social security stuff that should be kept private. Okay. Also, for condominiums that have 150 units or more, the law was changed a couple of years ago that you're supposed to have a website. Now, if you're less than 150 units, can you have a website? Sure. But if you're 150 units or more, you're required to have a website. Okay. And I'm not going to read to you this list that's right in your outline, but the website is required to be password protected, right? Only owners have access to it. But you're required to post lots of the official records on this website. And the goal is to make the official record process transparent, right? So if you're a larger condo, 150 or more units, make sure you have a password protected website. Make sure you're making available all the documents that are required in the statute. All right, couple questions. A question on the annual report for every condominium has to be filed with the Florida Division of Corporations. Their website is www.sunbiz, I'll spell that out, sunbiz.org. So sunbiz.org. There you can type in your association's name, and you should see, hopefully you have your active corporate status, meaning your annual report was filed on time. We got a question about the transfer fee. As I mentioned in 718, the maximum is $150. In order to charge that transfer fee, your declaration or bylaws, actually your articles as well, needs to have that authority. So if your governing documents, if your deck articles and bylaws are silent, you cannot charge a transfer fee. So if you're thinking about amending certain things, obviously, if you don't have that transfer fee authority, that's something you might want to consider. Okay, we got the how the minutes of the board meeting should be taken. It can be anyone that the majority of the board wants to take the minutes. Oftentimes the property manager does. It really can be any officer or anyone on the board. It's whoever a majority of the board wants. The minutes are part of the official records. Owners have access to them. We actually have an article on our website. Try not to pump our website too much, but we have lots of good articles. One of them is on exactly what the minutes should include, and I talked about that earlier. It shouldn't be a transcription of every word that was mentioned. It really is just when it was called to order, who was there, the motions that were made, who made them, how that vote was decided by each member of the board, and then the time the meeting was adjourned. Regarding official record requests, I got a great question. The way the statute works is, and the question is, what form does that request need to be in? 718 of the Florida statutes allows boards to adopt reasonable rules regarding the manner in which record inspections are made. And a rule that we think is reasonable, and we have lots of clients adopt, is a request to inspect the records must be made by certified mail. So if you don't have that rule in place, you cannot require it to be via certified mail. But if record inspections are becoming a problem, the board should certainly think about getting with your association council to adopt rules to address it. And one of those rules certainly could be a requirement that it's sent certified mail. Again, as far as the condo website and what needs to be there, our outline and our statute sets forth exactly what needs to be there. Those records should be password protected. And certainly if an owner makes a record inspection request and the item is right there on the website, you can obviously follow up with that owner and point them in the right direction to that site. We got another certified mail question on record inspections. Again, you need to have a rule that's adopted. So you need to have a majority of the board. There need to be minutes of a board meeting reflecting that these record inspection rules were adopted. and then provided to all owners. If that was done, those rules can include a requirement that a record inspection is sent via certified mail. Okay, we got a question on the new condo Senate Bill 4D. I thought I was pretty thorough and clear, but let me just repeat again. We're giving a whole course on that next Wednesday. We also have given approximately 5 courses already on that topic. It's way more in depth that I have time for today. I encourage you, if you haven't attended one of our courses on the new Senate Bill 4D, that you go to our website and check them out, or definitely sign up for one of these courses going forward. But it's new Senate Bill 4D. We've even published articles about it. You can find it on our site, or even a Google search should point you in the right direction. We got a great question. If the meetings are recorded strictly to help do the minutes, do you have to keep those recordings? The answer is no. There's actually language in Florida law that does not require those recordings to be kept if they're just made for the purpose of assisting with the minutes. All right, wonderful. Next topic, we're making pretty good time. I will keep to my promise. We, of course, will get to 5 topics, and I'll do my best to get to all 7. But the next topic is the election. And there's, election season typically is coming up. And I think it's important for the board to be aware of how the election process works. The election happens at the annual meeting of the owners. That's where the owners vote, okay? And there's 2 notices of the annual meeting that are required by statute. There's the first notice that is mailed 60 days prior, not 59 days prior, not 58 days prior, 60 days prior. There's a second notice of the annual meeting that must be mailed between 14 and 34 days prior. So not 35 days prior, not 13 days prior, but between 14 and 34 days. So the first notice, 60 days prior, the second notice between 14 and 34 days prior. Also, every owner that wants to be a candidate for the board must submit a written notice of intent to the association 40 days prior to the election. Not 39 days prior, not 38 days prior, but at least 40 days prior, okay? All of those individuals that timely submit their notice of intent to run 40 days prior, if they want, this is optional, but if they want their candidate information sheet, which is basically a resume, a 1-page, if they want their candidate information sheet included with the second notice of election, this optional candidate information sheet must be submitted to the association 35 days prior, okay? So not 34 days prior, not 33 days prior. What you practically see is someone wants to be a candidate for the board, they'll submit their notice of intent to run 40 days prior, and they'll just include their candidate information sheet, okay? So let's work out practically how an election will look like. Let's say you have a 5-person board, okay? You send your first notice of the annual meeting election out to all owners 60 days prior. I'm John Smith, I'm an owner. I get the first notice. Okay, I see the annual meeting is going to be on this date and time. It says, okay, if I want to be a candidate, I got to turn in my notice of intent 40 days prior. Let's say you have a 5-person board. Let's say you only get 5 notice of intent forms submitted 40 days prior. What does that mean? It means you got not enough intent forms for an actual election to be held, right? If you have 5 open seats, you only get 5 forms or 4 forms or 3 forms. There's no election. And the second notice that's sent out 14 to 34 days prior will simply state that the association received the same or less number of candidate intent forms as there are open seats. Therefore, there's no need for an election. at the night of the annual meeting, these 5 people or these 4 people or, or 3 or 2 or 1 even will simply be announced as the new board. Okay. And that makes things fairly simple and straightforward. But let's say you get 6 notice of intent forms timely submitted 40 days prior. The second notice that's mailed out between 14 and 34 days prior will now include a ballot, which will list those 6 candidate names in alphabetical order by last name first. And there should not be any stars by any candidate names that shows who's currently on the board or anything like that. Should just have the 6 names listed in alphabetical order by last name. In addition to the ballot, you'll have the 2 envelopes. Hopefully you all know in condos, the elections are done by the inner and outer envelope process. There's an inner unmarked envelope. It might just say ballot envelope. And there's an outer or an exterior envelope, okay? The way it works is I'm John Doe, I'm an owner. I get my second notice package of the election in the mail. I open it up, I see the ballot, I see 6 names for 5 seats. I choose which 5 I want. I can choose 4, I can choose 3, I can choose 2, but I check off which names I want. Put my completed ballot in the inner envelope, seal the inner envelope, take the inner envelope, put it in the outer or the exterior envelope, seal that up. And this is the important part. On the outside of that outer envelope, I must sign my name and my unit number must be there. Okay. That outer envelope must be signed by the owner. If you have multiple owners of your unit, it's got to be signed by whoever the authorized voting rep is. Oftentimes there's a voting certificate requirement where if a unit's owned by multiple owners, those owners must let the association know who's authorized to vote. So I'm John Smith. I fill out my ballot, put it in the inner envelope, put the inner in the outer, seal the outer envelope. I sign and put my unit number on the outer envelope. I can either bring my completed envelope to the election and cast it right there. I can mail it in. I can even give my completed envelope to my friend to take down for me. That's fine. What's not fine, and what I want to make abundantly clear, is there is no proxy voting for the election. What does that mean? It means you can't authorize someone to vote for you. You're the one as the owner that must fill out the ballot. You're the one as the owner that must sign the outer envelope. Again, you can hand your completed envelope to a friend to walk down, but that's not proxy voting. So proxy voting is not allowed. At the date of the election itself, the way the law works is for the election to happen, you only need 20% of the owners to cast their vote, okay? So the law makes that 20% somewhat of a low number because they want to encourage elections. So the magical number for the election to happen is 20% of the owners must cast a vote. At the election itself, there should be a current owner roster. You've got the big stack of envelopes, and you should have whoever your election committee, it should be impartial people, just not on the board. Before anything's opened, you need to check off on the owner roster which units cast their vote. So you have the big stack of sealed envelopes. You look, oh, John Smith owns unit 101. Check off on the owner roster that John Smith cast his or her vote. Okay. If you're a large condominium, and this check-in process sometimes can be the longest process, right? We have lots of condos that are 300 units, 400 units, 500 units plus. That envelope verification process can take a long time. The law allows that verification process to happen before the election, provided that notice of that verification meeting is posted 48 hours prior, and owners get to attend it. But let's say you have your election scheduled for 5 p.m. It might make sense for you all to have your envelope committee verification meeting scheduled for 3 p.m. that same day. That way, when it gets to 5 o'clock, a lot of the administrative verification process is done. Obviously, an owner can still bring their ballot at 5, and you would still need to check it in at that point in time. Well, that's a good practical tip. For those certainly larger communities, you can verify the envelopes prior to the election itself, just provided that you notice that meeting in advance, and certainly you can't preclude owners from attending it. All right. I want to just touch base on a couple other election matters. Eligibility to be on the board. There is a misconception out there that the Florida statutes require board members to be an owner of a unit. That is wrong. Okay, now, most governing documents require board members to be an owner. The way it'll read, it will require board members to be members of the association, and then the term member is defined as an owner. But it would be inaccurate to state that all board members of all condos have to be an owner of a condo unit. Again, a lot of documents require it, but you need to check that. You might be thinking, why would a non-owner have any desire to be on a board? And we have certain clients where their documents don't require board members to be owners. And we have some non-owners. We have long-term tenants that have been there for 20 years plus, and she's very invested in the way things are run. And she's served on the board for a long time, and she's been a valuable member of the board. Now, if you're thinking that seems odd, we want to make sure all board members are owners. Again, get with your association counsel, confirm that that's what your documents require. If it does not, you need to amend your documents to require that. Okay. A couple other eligibility things that I just want to point out. If an owner is delinquent in the payment of their assessments to the association on that 40th date that the notice of intent needs to be turned in to be a candidate, if that person is delinquent, they're past due, they're ineligible to run for the board. And the board should send them a letter, dear John Doe, we've received your notice of intent to run for the board. However, the association records reflect that you're past due. Therefore, pursuant to Florida law, you're ineligible to run for the board. Okay, so it's just important to know that when that 40th date comes and goes, and you're on that 39th date, you want to review the account status for those candidates to make sure there's no delinquent ones there, because if so, they shouldn't be included on the ballot. What I will say is once someone's on the board, they're automatically off the board if they're more than 90 days past due. Okay, so once you're on the board, it's a 90-day time frame that forces that person off of the board. Also, just a brief thing on eligibility. Co-owners of a unit are not eligible to be on the board at the same time unless they own more than one unit, or there's not enough candidates for an election. Let's say you have a 5-person board. You only get 5 people submitting a notice of intent to run, so there's no need for an election. 2 of those 5 are co-owners of a unit. The law doesn't allow them to run. The term for board members, unless your bylaws or articles of incorporation state something else, and sometimes they do. I've seen 2-year terms. I've seen staggered terms. But unless they state something else, it's a 1-year term. Regarding how long board members can serve, the law was changed July of 2018 that there's an 8-year term limit. So you don't need to worry about this until 2026, okay? That 8 years starts when the law was adopted, 2018. But there's an 8-year term limit for board members. But again, you don't need to worry about that until 2026 because that's 8 years from 2018. Now, even if it's 2026 and there's been a board member serving 8 years, he or she could still serve 9 years if there's not enough candidates for an election. So the same fact pattern, 5-person board, you only get 5 candidates. It's the year 2027, it would be someone's 9th year. That person could serve the 9th year because you didn't have enough candidates for an election. That's exception 1. And again, this is right in your outline. Exception 2 is that person can serve a 9th year if they got 2/3 of the votes were cast for him or her. And the point behind that law is, look, if 2/3 of the community wants this person to stay on the board, that's a wonderful thing. And he or she should be allowed to serve a 9th or 10th year. All right. Couple other topics, and then we'll go on. We only have 2 more topics after this, and I'll try to go as quickly as I can. But board members, you need to be certified, okay, within 90 days after being elected or appointed to the board. You must take a board certification course, just like the one you're in now. All right. There's really no teeth in the law if you don't do it, but I think it's important for board members to do it. You can be certified again by taking a state approved course, or you could sign a very simple statement. I call it the Scout's Honor, that just pretty much says that you agree to read the governing documents and uphold them to the best of your abilities. Okay, so just be aware of that board member certification requirement. Again, if it's more than 90 days, the law says you're temporarily off the board, but you're automatically put right back on once you either take that state approved course or just sign that simple sheet. If there's a vacancy on the board, let's say a board member, God forbid, passes away or he or she resigns, the way the law works is unless your bylaws say something else, the remaining members of the board have the authority to appoint someone to fill that vacant seat, and that replacement director will serve the unexpired portion of that board member's term. Okay. And election challenge, let's say you have your election, an owner says this was done illegally, you guys did everything wrong, I'm going to file legal action against you. That person who wants to file an election challenge has 60 days from the election. So if it's more than that 60-day time frame, you can pop the champagne after that. Any election challenge would be time barred per the statute. I do want to just touch base on 2 more quick things in this this election chapter. I had a question earlier, way back when I was talking about operations, about the recall process and what does that mean? Quite simply, the only way you can completely remove a member off the board entirely is if they're more than 90 days past due, right? They're automatically off, or if the community undertakes the recall process, which requires a majority of all of the owners to agree to recall that member or multiple members of the board. Okay, so it's a majority of all owners. So if you have 200 units, you need 101, 50% plus 1. You need 101 owners to agree to recall that member of the board. If you're a concerned owner group and you're thinking about recalling the board, I would get with an attorney because there is procedural requirements to make sure that you do the recall correctly. Under that same sort of thought process, if you're currently on a board now and a majority of the board receives a recall attempt, I would get with the association's attorney as soon as possible to confirm whether that recall was done right. I will say recall can be done without cause. So it could be because the wind blows a certain way. The owners don't need to prove that the board did anything wrong. It could be without cause. But the key is it needs to be a majority of all of the owners. I just wanted to touch base on that recall process. The last thing is electronic voting. Hopefully you all know the law was changed a few years ago to allow owner votes to be done via electronic voting. It's not as simple as sending an email blast and you can just send a quick AOL response back or a Gmail response back. You do need a third-party voting program where owners sign up. There is a process in the statute to implement electronic voting. If you're thinking about it, I think it's a good idea. You want to get started with as much lead time as you can. It is just a board vote. to implement electronic voting. However, an owner still needs to consent to participate in electronic voting. So if you have some owners that prefer the quote unquote old school way with the ballot and the envelopes and all of that, you cannot force them to use electronic voting. But certainly electronic voting can be a very practical and effective way, certainly if you're in a larger condominium community. If you want to discuss or what the steps are, get with your association's attorney, because the board does need to adopt a resolution at a board meeting that contains certain things to properly implement electronic voting. And again, the owners still need to consent to it. So you could have a split community where if you have 200 owners, you could have 140 that agree to electronic voting and the balance votes the old school way. All right, let me see if there's any good questions on this. We got a question about reserve funding and how much money is needed. How do we know that? You should really be getting a reserve study done by a qualified professional who comes out and who inspects what those infrastructure items are and how much remaining useful years you have left. Regarding the notice of intent to run for the board, that must be submitted 40 days prior. I suggest putting in the first notice of the annual meeting exactly the address where the notice of intent must be sent by and the means in which that notice of intent can be turned in. Email is certainly fine, but I would just specify that so all owners are on the same page. I get a question asked a lot. Do current board members need to submit their notice of intent to run? The answer is, if their term is going to be expiring, yes. If they're only serving a one-year term, then their term expires the date of the annual meeting. So if they want to be on the board again, or they want to run for the board again, they absolutely must submit their notice of intent to run 40 days prior. If the bylaws or the articles allow for 2-year terms, obviously if they're only served 1 year, they're still in the middle of their term. They don't need to serve, they don't need to submit another notice of intent to run. All right, if there's not enough candidates to be on the board, let's say you have a 5-person board, you only get 3 notice of intent to run. Those 3 people, they're seated as the new board. Then those 3 amongst themselves, they vote to appoint board member 4, and then those 4 amongst themselves appoint board member 5. I got a very specific question about how owners retrieve the ballot. Can they get it from the management office? Where can they get it? They said they didn't get it by mail. It needs to be mailed. If for some reason, sometimes certainly there's, no one has control over the U.S. post office. If an owner says they didn't get it by mail, certainly you want to have extra copies of the ballot available at the meeting itself. Owners absolutely have the ability to vote right then and there. You also could certainly allow them to retrieve a ballot from the management office, let's say. At the end of the day, each unit only gets to vote one time. And once you vote for the election, you cannot change your vote. So you're going to check off. That's what the envelope verification process is for, to make sure each unit only votes one time. And it's the first vote received, that's the one that counts. An owner cannot change their vote for the election. I got a question. Is it odd that our governing documents do not include term limits for board members? In my opinion, it's not odd. That's fairly common. Lots of communities have a hard time finding people to run, and the statute has that 8-year term limit. Again, it started from 2018, so you don't need to worry about it until 2026. We got a great question from one of my favorite managers out there, who shall remain. I won't say their name, but the question is regarding the voting certificate process. Again, the voting certificate process is where the documents, the articles, or the bylaws say if a unit is owned by more than one owner, they must submit a voting certificate where both of them sign it saying this is who the authorized voting rep is. So If I own a unit with my brother, we sign a voting certificate saying that I'm the authorized voting rep. Again, it's document specific whether you have that voting certificate requirement. If you do, it should be enforced. If you haven't enforced it in a long time and you want to start enforcing it again, you should include language in the first notice. You want to include a voting certificate letting the owners know these are the fact patterns where you have to have a voting certificate, and the association will be using them. Now, if you have a voting certificate requirement, let's say me and my brother both own a unit, the documents require us to have a voting certificate on file. Let's say we don't have one on file, but me and my brother both sign the outer envelope. In my mind, that's totally fine. You can accept that vote because we both signed it. We had a question about if there's not enough candidates for an election, because let's say you're a 5-person board, you only got 5 seats, do you still need to have the annual meeting? The answer is yes, you should, where you can simply just announce this is who the new board is, but you still are technically required to have an annual meeting each year. I got a question on a multi-condominium and sort of the owner participation. That's a document specific thing that I would need to review the particular governing documents on that. I got a very specific question about the board or the management company not sending out notice of the election properly, and an owner that may have had a bona fide objection to that. I certainly encourage that person to either consult with an attorney to see what rights you may or may not have, with the reminder that you only have a 2-month time frame to challenge any election that may have been done wrong. All right, we got a question is it wrong for basically board members to campaign for themselves? I don't think that's wrong. You know, board members can certainly express to other owners why they think they're the best fit for the community. I think it's probably more appropriate for a management company to remain independent. There's certainly no law that specifically states that a property manager can't say, I think this person has done a good job. The notices I stated for the annual meeting, those are calendar days, just calendar days, not working days. So you count Saturdays and Sundays. So the first notice is mailed 60 calendar days. The second notice is mailed 14 to 34 calendar days. And the notice of intent must be turned in 40 calendar days. So you count every single day. We had a very specific question about term limits. There's 4 board open seats. It's a larger board. Some of the board members are ineligible. Is there election required? Obviously, hopefully you can appreciate that's a very fact-specific question outside the scope of my ability to accurately address right here. So get with your association's attorney as far as who's eligible or not. We got a question, can the board vote another board member off the board? I thought I addressed this. The answer is no. You need to go through the recall process where you need a majority of the owners to approve that. The only thing board members can do is they could strip someone from serving as an officer role, right? Officers are just president, vice president, treasurer, etc. The board amongst themselves can reorganize the officers, but that person still stays on the board. So the answer is no. The board cannot get rid of a board member completely amongst themselves. Okay. We got a question with, it's a 5-person board. We only got 3 notice of intent to run forms. They're having a hard trouble finding those other 2 seats. Can the condo still operate with 3? The answer is yes. You'll still have a quorum, right? Quorum is majority of the board, but you got to make sure that all 3 board members are at every single board board meeting. All right. Just want to touch base because I promised we would get to all 7. This next one, the dispute resolution. The reason why I'm quickly going over this is something your law firm, your association counsel handles. Okay. This is when you're enforcing your rules. All amicable attempts have failed. You've sent demand letters out. You find them. You've done everything you can. But at the end of the day, it's all failed. And the board throws their hands in the air. What can we do? And the answer is you can refer the matter to formal legal action to your association counsel. And there's a detailed pre-suit mediation process that condos can now take advantage of, where an impartial third party tries to resolve it. If that mediation process does not work and impasse is reached, then association can actually file a lawsuit in state court. You can go over the outline yourself. I don't want to take up time, but just know this is when all attempts to resolve a rule infraction has failed. You do have rights. You do have the ability to go through the formal legal action process. The last topic, and I will take questions on that, but the 7th and last topic, and it's 204. So I'm doing pretty good. The last topic is contracts and bids. And let me just get on my high horse for a second, just indulge me. Because I've seen fact patterns time and time again, and it still leaves me scratching my head. If you're on your board and you get a proposal from a vendor you're thinking about, and you as the board are not clear on the who, what, where, when, and how, do not sign it, right? It does not matter what the smooth talking salesperson promised you, okay? What matters is what's on the 4 corners of that contract. A judge will only look at the 4 corners of that contract. So if someone promised you something, it should be in the agreement that you will sign, okay? Also, for service contracts, whether it's landscape services, pool maintenance, even your management company, we suggest, it's not required by law, but we suggest and makes sense to have language that allows the association to terminate without cause by providing, preferred 30-day notice, maybe, 2 months notice, maybe 90-day notice. But we think it's a good idea to have without cause termination. Why? Because that way you don't need to prove that the vendor breached anything to get out of that services contract. Vendors are wonderful human beings, but I've yet to meet a vendor who says, you know what, board, hand up, we screwed up, we breached, we defaulted, you're free to go. It just doesn't happen, right? Rather, they'll say, well, we're entitled by the contract to get notice of the breach. We have an opportunity to cure. Who gets to say whether it was cured or not? It can just get very complicated, very expensive. And who wins? The attorneys, certainly not the associations. So we think it's a good idea to have without cause termination. That way it could be because the wind blows. So that's a good practical tip for you all as well. Certainly, if your contract is of any significant length of time or any significant cost, to me, it makes good sense to have your attorney review it before it's signed. Perhaps to draft language to better protect the association in a manner that's still fair to the contractor. If you're spending $100,000 on a contract, to me, it's probably worth it to spend $101,000 to make sure you're adequately protected. I can't tell you how many fact patterns I get. Some of the nicest, most well-intentioned board members, even managers. Andrew, we have a problem. What's the problem? The problem is we have a vendor that we can't get in touch with them. We gave them 50% of the money down. We haven't heard from them in a month. The project's barely started. I then asked to see what contract was signed, and it's like a 1-page handwritten thing with no obligations, no protections at all. And we are very, I think, effective and aggressive, and we're going to advocate on our client's behalf to the best of our ability. But at the end of the day, if the contract leaves you exposed, it's going to be an uphill battle. So this is me on my soapbox for a second, but I do think it's important for you all to really take your time before anything is signed. Regarding competitive bids, getting multiple proposals, the way the law works is if that contract is more than 5% of what your annual budget is for that year, you must get competitive bids. Competitive bids just means more than one. Obviously, 3 is a good number, but technically 2 is competitive bids. The exceptions are you do not need to get competitive bids at all if it's a contract with your attorney, your accountant, your manager, your engineer. That list of exceptions is right there. Can you still get competitive bids? Of course, it might be a very good idea, but you're not required by law to get competitive bids for those exceptions. Last topic, conflict of interest between board members and how that works, right? We get asked a lot, is it a conflict of interest? And the way that it works is that, let's say a board member, owns a landscape company. The board's thinking about hiring that landscape company. Are they allowed to? And there's detailed language on the disclosure requirements that must be followed. Okay. And it's right in your outline. I have some boards that just say, we think it just looks bad. It's optics. It doesn't look good. And I don't disagree with that. And if the board chooses to just never hire any, company that's that's owned by a member of the board, I think that's certainly appropriate. But I just wanted to point out the disclosure requirements that must be made for any potential conflict of interest. Hold on just one second. All right. With that being said, it is 2:10. Let me take a couple questions. Question is, does board have to approve contracts? The answer is yes. A majority of the board should absolutely be approving contracts. Certainly if a majority of the board has previously authorized, like the president, to approve something, that's okay. But there needs to be a record that a majority of the board has authorized that. We got a question, is it okay to sign a contract without our attorney reviewing it? Well, the answer is, of course. It's a business decision of the board when to engage legal counsel. I'm just suggesting that it's much better in my mind to spend a little money up front versus signing a contract that has no protections. Then things go sideways. You're going to be spending a lot more money after, but ultimately it's the board's call. I got a general question, which makes me sort of smile. What if a board member just seems really friendly with a contractor? Not quite sure how I could answer that. On the face of it, I encourage all board members to be friendly with everyone. And I also encourage people, I get a lot of these allegations sometimes that are thrown around that board members are quote unquote stealing or board members are misappropriating funds. In my mind, that is a very serious allegation that can actually, without proof that that's actually happening, can expose the person who's stating that to third parties. It could expose you to a cause of action for slander, for libel. So I just would encourage people to be somewhat cautious with what sort of allegations are thrown out.